So judgment has been reserved in the ANC's case over the use of the Umkhonto weSizwe name and logo. The governing party wants the High Court in Durban to stop the MK party from using the name and logo that they say is linked to its former armed wing. The ANC failed in its bid to have the party deregistered and removed from May's ballots. Now the ANC believes that there has been an infringement of trademark. So let's talk a little bit about this, particularly the issue around trademark. And for that, we are joined now via our video link by Professor Owen Dean, who's Emeritus Professor of Mercantile Law at Stellenbosch University, specializing in copyright. Prof, good morning to you. Thank you so much for joining us. We've got, and throughout this discussion, we'll put up the logo, of course, of the MK party and even the MK structures of the ANC, particularly during the struggle, and we can have an analysis. But I think just looking at the story from the very beginning and as you've watched it develop, just starting thoughts, do you believe that the ANC has a case here?
Well, first of all, good morning and to you and to your listeners, and thank you for inviting me to your program. Yes, well, it's in principle they do have a case. It depends a lot on the facts of the matter, which I don't have at my disposal. But in essence, it does have a case.
Yeah, and let's talk a little bit about then what the MK party would then have to do in court to then counter that case. Because we need to talk about what it is exactly that constitutes a trademark and copyright, right? So perhaps let's start there. What is it that for the ANC would help their argument to say that this is trademarked, the name and logo is ours and it cannot be used? Let's start there. How would they prove that?
Well, there are two ways of getting protection for a trademark. Now, a trademark is essentially a brand, and a brand can be a word, it can be a combination of words like it's finger-licking good. It can also be a picture of sorts, which is known in trademark jargon as a device or a logo. And the function of a trademark is to denote the origin of goods or services. In other words, a trademark tells you that this is the product of somebody. You don't need to know who it is, but it identifies the source of the product. Now, you can get protection for a trademark in basically two ways. You can register it, which is the best way of doing things. Then you have a statutory right. Alternatively, you can acquire rights to a trademark under the common law through using it on an extensive scale. If you build up a reputation in a trademark, then the common law will protect that reputation. In other words, the public out there must recognize the trademark as being the trademark of a particular entity. Now, as I understand it, the ANC at this stage doesn't have a valid registration of Umkhonto weSizwe or of the picture, the logo, the device which is being used by the MK party or similar to it. So they're relying, as I understand it, on the common law, which means that they have to show the court that they have a reputation that in the eyes of the public, Umkhonto weSizwe or MK or the logo identifies them. And the public, when they see that logo, they think they're dealing with the ANC. Now, for MK to defend that case, they have to say, well, that is not true. This mark or the logo or the name is not identified with the ANC. It's in the public domain. It might have had some significance many years ago, but that was with the military wing of the ANC, which may or may not be a different entity to the ANC. But that's long gone, and so the reputation has ceased to exist. Therefore, we are free to adopt it. That would be their argument.
Yeah, we've got up on the screen the logo of the ANC, the party itself, and the logo of the MK party. And then what we're going to do, and you may not be able to see these, Prof, but I certainly am doing it also for the benefit of our viewers. What you see there on the right is the logo for the MKMVA, right, the Military Veterans Association. On the left, the logo for the MK party. Now, I don't know if you can see these, Prof, but I'm going to explain them to you. You certainly do have the image of a man, so this is essentially the graphics that you're seeing, a man holding a spear and a shield. For the MKMVA, the spear is held above the head of the man. For the MK party, the spear is held at the side of the man. Those little intricacies, Prof, can they work to the benefit of the MK party in court? Those little slight changes to the logo, for instance.
No, I don't believe they can, because in trademark law there's something called the doctrine of imperfect recollection, which means that you have a sort of a picture in your mind's eye of what a logo looks like. You may not know the detail, and when you see a competing logo, you gloss over the detail and you take the general impression. And from what you explain and from what I've seen of these two logos, I don't have them before me, unfortunately. Sure. They are pretty similar, and I don't believe that you can avoid the trademark infringement claim by saying that they're not confusingly similar. So it's all going to, the trademark case is all going to turn on whether the ANC can prove that they still enjoy a reputation in their logo, and that the public identifies it with them. Now, you mentioned that you mentioned an organization called the Veterans Association, or something like that. Yes. Now, you see, that could be a problem, because for the ANC, who is the party that has brought the case, they have to show that the reputation vests in them. It doesn't help if they show it vests in the Veterans Association, because my understanding is that the Veterans Association is a different entity. So that could be a problem as far as the ANC is concerned. But you mentioned copyright as well. Yes. And this claim is also based on copyright infringement. Now, copyright infringement is a totally different kettle of fish. There, what you would claim is that we have an artistic work. Somebody sat down and designed our being the ANC, designed our logo, and we have copyright in that artistic work. Now, whether they own that copyright is another matter, because what the law of copyright says is that the individual who makes the work is the initial copyright owner. So for the ANC to come along and say that you are infringing our copyright, they would have to show that they own the copyright. The copyright undoubtedly exists in that logo, because it exists automatically. You don't have to register it or anything like that. Right. So the issue is, does the ANC as a legal entity own that copyright, or does someone else own that copyright? Yeah.
Well, this is the argument they've made.
From a copyright point of view, just let me finish. Sure. From a copyright point of view, I think that there would be the two logos are sufficiently similar for them to be an infringement of copyright. So once again, the ANC's copyright claim turns on whether they can show that they and nobody else owns the copyright in that logo.
Yeah, and you talk about ownership. So this is the argument that they've put forward. The ANC has cited that the registration of the Umkhonto weSizwe trademark is owned by the MK Legacy Project, which was subsequently transferred to the ANC. And those are the technicalities that we're going to get into. Just as we wrap up, Prof, a final thought from you. Do color schemes matter? I mean, where the argument then becomes, well, green, black and gold is a color of the African National Congress and then cannot be used by the MK party. Could that be swayed in any way to the favor of the ANC or the MK party?
I don't think that in general the ANC can claim a monopoly in those colors. If those colors are used, or similar colors are used in the logo, then the similarity in colors will contribute to the similarity of the two competing works as a whole. But I don't think the ANC can claim that they own those particular colors. They would have a hard job in doing that. It's not impossible. One can get trademark or common law protection in colors, but it's a difficult job to prove it. And it will depend on what evidence the ANC has put forward, because they have to convince the court by means of evidence. You can't just come along and say so that I own these colors or I own this logo. You've got to demonstrate, you've got to give the facts from which the court can conclude that you have a reputation and that the public identifies those colors or that logo or that name with you. And that's quite difficult to do. Whether they've, as I say, I have not seen their evidence, so I can't express any view as to what their prospects of success are. But what one often does in this situation to prove a reputation is to conduct a market survey. And then you come along with the results of the survey, which shows that 80% of the people, or whatever the percentage is, who participated in the survey identified the logo, the colours, the name, etc., with the ANC. Now, whether the ANC have done that, I really don't know. One would have to look at the evidence.
Yeah, I think what's most interesting, though, about this battle as it goes on is that it's not as cut and dry as a lot of people think it is. And so what comes out of the court really is going to be considered to be precedent setting. But that's all we have time for, Prof. And thank you so much for your time. That was Professor Owen Dean, Emeritus Professor of Mercantile Law at Stellenbosch University, specializing in copyright.